let me give all of you a very warm welcome on behalf of the South Center. As you know, the South Center as an intergovernmental organization has worked during the last years on this area of investment. So you are quite aware that this international investment regime is a fragmented system. It's a system which is asymmetric in terms of the interests of the states and of investors, to the detriment of the interests of the states, for sure. It is a system based on very vague standards, unpredictable decisions. It is prone to abuse. So the South Center has been very much concerned about the implications of the investment legal system in developing countries. Some of them, including my own country, Argentina, have suffered a lot from the inequalities and the gaps in the system. So this webinar is about the international investment system in a particular context, in the context of COVID-19. As we know, this pandemic has raised a number of challenges to the developing world. It is not only a health challenge, it's about the economy. As we know, many of our countries are suffering a lot from the confinement. There is a decline in the economic activities. There is a decline in the capacity of the countries to get essential income through the taxing system. There are many challenges that developing countries are facing now because of this pandemic. And one additional challenge that our countries may face is the challenge of investors' disputes. In fact, there are some indications that some law firms, sometimes the lawyers, the attorneys act as entrepreneurs. Some law firms are looking for cases that could be initiated in the context of COVID-19. Certainly a number of developing countries needed to adopt measures in order to face the various facets of this crisis. And some of these measures may have affected the so-called investor rights. So therefore, there is a risk, a growing risk, that many developing countries have signed up to these investor agreements protection, may face in the near future some of these disputes arise. The Colombian Center on Sustainable Development issued a couple of months ago a call for a moratorium on cases of investor-state disputes, and the South Center was very glad to join this call for a moratorium. I'm sure that Liz Johnson will make reference to this. So we need to help developing countries to take preventive measures in order to face this risk of a growing number of cases that will be brought under this investment, very fragmented and unpredictable investment system. So we are very happy today that we have a very stellar panel to address different issues. So thank you very much for the speakers to participate. Thank you also for the moderator. This webinar will be moderated by Mariama Williams, Dr. Williams. She is the coordinator of the South Center program on climate change, sustainable development, and gender. And she's also covering these issues of investment. And the first speaker, the kickoff speaker, we are very proud to have Professor Sornaraja, very well known in this field. So I've been a frequent reader of many of the books and articles produced by Professor Sornaraja in the past on this and other issues. So I have admired very much his work. So we are very, very, very honored to have him in order to initiate this discussion. So with that, then I will give the floor to Professor Sornaraja to kick off the discussion. Thank you very much.
Thank you so much, Professor Correa, for inviting me to talk to the South Center and to the others who are attending this webinar. As Professor Correa has said, it that that states have taken in response. At the conclusion of every crisis, we have seen a spate of cases, spate of answered. The Argentine economic crisis, the global crisis, 2008, and against Spain in respect of investments that made in this faces a crisis, and lawyers, as adverted to by Professor Correa, are like vultures circling a battleground in order to find as many people affected as possible against whom they could bring claims. So we are going to get gored and kicked at a time when we are least able to sustain large amounts of compensations are awarded in these different claims. As you know, the measures that were taken by governments, like lockdowns, like the taking over of foreign-owned hotels to run quarantine centers, or foreign-owned hospitals to treat their patients, the closing of roads, the closing of airports and seaports, the imposition of exchange controls and export controls, all these different measures that were taken by the various states of the world are very similar, but they also amount to violations of the principles of the many investment treaties that have been made, particularly by the developing countries, which are at which are the targets of these treaties. So at this time then, we are going to face a large number of treaties at a time when we are least able to face them. These measures that have been taken are clearly measures that amount to expropriations, as for example, where a hotel is taken over as a quarantine center, or would amount to violations of the fair and equitable treatment, as for example, where price controls are imposed on medicines, and there would be other allegations such as discrimination against foreign investors that would provide the basis of different claims. More importantly, also, one must remember that many of the developing countries will be unable to service the loans that had been given to them or the bonds through which they had raised capital. And as is well known, there is a category of cases under investment treaties in which the sovereign defaults give rise to different claims. It is true that these claims can be met with a series of defenses that are available to states. Obviously, one would be the national security defense, which is to be found in many of the investment treaties. And in modern times, of course, the national security defense is not confined to military threats, but is also available in other instances. Like, for example, in the case of the pandemic, one could argue that there is a national security threat that has arisen because in the meeting of the pandemic, governments had to declare emergencies, ensure that the military was called out to enforce some of the measures that had been taken. Clearly also there are other defenses available, like for example, the necessity defense, the force majeure defense, and the defense, of course, that the measures that were taken were regulatory measures. We have a very old case decided in 1906 relating to the seizure of a carriage which had transported persons having a smallpox disease, and the tribunal in 1906 held that such a taking, the seizure or the carriage, would be regarded as a regulatory taking which would not carry compensation. So it is true that there is a plethora of defenses that are available, but these are new developments. And of course, one problem we have is that many of the treaties that we still have are the old type of treaties that have emphasized investment protection, and not the new type of treaties which seek to promote sustainable development and hope to reserve a regulatory space for states. So one has to then think in terms of alternative measures that one could adopt in order to confront the crisis that would arise very soon. So I have about 7 to this. Some of them might be disconcerting, but do bear with me as I go down these 6 different measures. First is that the old-fashioned treaties we have should be terminated. That would be a founding idea. That should not be simply because of the fact that treaties are being terminated right now. The European Union has terminated all the intra-European investment. So there is one significant instance of termination of treaties. Then we have India and Indonesia terminating their treaties unilaterally, along with the clauses. You must remember that when you terminate the treaty, that clause which keeps alive the investor's right 15-year period after termination. So unilateral termination, I would argue, is possible. It is possible because the Vienna Convention on the Law of Treaties permits unilateral termination on 2 occasions. First is where there is a changed circumstance. Obviously, the pandemic that has arisen is a changed circumstance. It is an altogether different situation that the whole world has had to face. So in that context then, if a treaty is being made now, it is pretty obvious that the draftsman of the treaty would have taken this circumstance into account. The fact that the whole world is facing a pandemic of this sort means that there must be novel situations that need to be adopted in order to confront this different circumstance that has arisen. So I would argue that in terms of the law of the sea, or the law and treaties, it is possible to terminate existing treaties unilaterally along with their sunset clauses. The second ground on which such termination is possible under the Vienna Convention on the Law of Treaties is where there is the new jus cogens principle which has arisen. I would then argue that the protection of life is such a jus cogens principle. So what is happening here, I would say, is that there is a need for the protection of the health of the people, that protection is a sacrosanct principle of international law, which has developed over the years in order to become a fundamental principle of international law. Then the further argument is that because investment treaties of the old variety conflict with this jus cogens principle, they must give way and should be and their termination should become possible. The third argument is, of course, an argument that I am quite often associated with. It is that the investment treaties were obtained by fraud. There was a promise of economic development in the preamble of the treaties, and no economic development has ever taken place. The only people who have had economic development are the lawyers and the arbitrators who have earned an exorbitant sum of fees as a result of the litigation. So that's the first method, termination of treaties, unilaterally if needed. I think most countries would agree to the termination because all countries have model treaties now, or the major countries have model treaties, which are of a variety that would accommodate regulatory space for states. So my proposition is that termination should become possible if not if not with the consent of the other state, then unilaterally. The second suggestion is that the treaties could be suspended. Again, the Vienna Convention on the Law of Treaties provides for the suspension of investment treaties. Again, the reasoning would be that circumstances have changed and there is a new jus cogens principle which has arisen. The third idea, again, is an idea which has been followed by some Latin American countries, and that idea is to withdraw consent to arbitration centers. So this is a strategy which has been adopted by Venezuela, Bolivia, and Uruguay. So in accordance with that strategy, then, one would say that, there would be a withdrawal of consent to arbitration centers, which would mean that there could not be claims made against the state which withdraws on the basis of the violations that it makes in the course of the pandemic. Alternatively, I would say that the consent could be confined to disputes that arise from measures taken in association with the pandemic. The fourth idea is what I call a Singapore solution. When the pandemic arose, Singapore quickly, within about 9 days of the pandemic, made a legislation which stopped any litigation or any arbitration in respect of disputes arising from certain types of contracts, which were detailed in the legislation. Though the legislation says that international arbitration could be possible, I would argue that if we make legislation of that type in the South, it should suspend all litigation or arbitration arising from contracts, including foreign investment contracts. So this would ensure that for a period of time, at least, there would not be domestic arbitration, domestic litigation, or international arbitration that is brought in respect of measures taken in relation to the pandemic. So the Singapore legislation, the experiment that Singapore has conducted is an instructive one, which I would advocate should be followed by other southern countries. The fifth is the moratorium. I shall not say very much. Professor Correa has adverted to it, and Liz, my friend from Colombia, she is going to talk about it later, so I shall not talk about it. The sixth one, of course, is the idea of shaming multinational corporations not to bring such legislation. After all, it's a matter of corporate responsibility that when people have to suffer, multinational corporations also have to suffer along with them. One might call it a moral idea, but it is also an idea that is increasingly coming to be accommodated within the notion of corporate nationality, corporate social responsibility. So I would say that as a matter of corporate social responsibility, multinational corporations should be subject either to a legal or a moral pressure not to bring claims against developing countries, particularly at this time when they are facing a major disaster. The recovery period also will involve problems. If this pandemic ends, there would be a need for recovery. And here is where the raising of past funds, sovereign defaults would come about, and again, there would be new actions that are brought about. So the measures that I have suggested would become relevant. Then, of course, if new medicines are found, then the issue is of patenting them. There would be notions of compulsory of parallel import of these drugs, again, we will have to take responses in accordance with the problems as and when they arise. I believe I have exhausted my time, and thank you so very much for listening to me patiently. Thank you.
Thank you very much, Professor. Your timing was actually quite perfect. You took exactly the time that I had written down on my note. Sir?
Yeah. Yeah.
Thank you very much. I am really, and I think the panelists will have some time to engage, and we're not going to do question and answer. You'll be with us for the entire period, Professor? Yes?
Of course, of
Okay.
course.
So what I
Of course,
propose to
Mariam.
do is
Okay.
we move to each of the panelists, and each panelist have about 10 minutes or so to make their intervention. And then we will open up the discussion, but both taking questions from the chat function. So I see that we have a number of participants, and welcome all of you. Thank you very much. So we'll have each speaker speak, and then please use either the chat function to make your comments, and you can comment with each other, and the Q&A question. So we'll have someone monitoring, and I'll keep an eye, and we'll ask you either to speak to your question or read your question as much as we can. We're hoping to leave a good 20 minutes or so for interaction between panelists, as well as taking some questions. So I'm going to quickly move on. I really thank the professor. I think you've painted a really good landscape of some of the dangers, the pitfalls, the concerns that are facing developing countries and most other governments also, but we are most vulnerable, of course, and some of the actual strategies and tactics that has been used by governments, such as the Singaporean strategy, what has been used in Latin America, and the 6 different strategy that you spoke about. I hope we get some time to discuss those. I know that Lisa will speak about at least strategy number 5, which is a moratorium, but it would be very interested. And I'm sure the people on the panel from the different, on the panel and all, as well as the audience, will have some really good perspective to share. So I won't say much more than that, except welcome everyone. Thank you, Professor, for a really wonderful introduction and opening to this debate, this discussion that South Center is very happy to be part of. And thanks to Danielle and Danish for organizing it, and for Lise and for all of the speakers who have agreed to be here today, and Professor Carlos Correa for opening up the panel, which is very good and pointed remarks. So it's a very serious matter, and it raises the question of, for me, in my head, I said, have we given up? Do governments give up their right to regulate in the public interest once they have signed onto these agreements? And the professor has outlined many different reasons and rationale on which government signs agreement, believing that those agreements will protect them under international treaties and laws, such as the regulatory issues, the issues of the health, and protecting the national interest. However, we note that with the what one lawyer, a very well-known lawyer in this field, has said, we're now in the Wild West of arbitration procedure, that there is no formal jurisprudence, that tribunals make up the rule as they go. And so you cannot really count, you can have a very valid argument, even one that you think is protected under the Vienna Convention and treaties, but arbitrators will do as they will. And currently states have no recourse. And the good thing is that now states have been for many long time paying a lot of these ridiculous, onerous claims under secrecy and so forth. But now it's open, and we have a lot of civil society, lawyers, judges, all making a pronouncement on it. And here we have some of the best on this panel to give us their impression and their thinking on it. So I'm going to move right into it now, if I can find my list, which I seem to have misplaced. So here, so we're going to have Chantal. Chantal Onai Wu is a trade policy and legal specialist in the Office of Trade Negotiation for the Caricom. And Chantal, welcome. Thank you so much for joining us from the region. And the question that I'm going to pose to you is, what is Caricom's response on possible challenges and perspective on the reform of international investment dispute arising from the experience of coping with the impacts of COVID-19? I'm not sure what's going on in the region. So far, I haven't seen any discussions about threats to us, but we are a small island, so therefore very vulnerable, and we're very much indebted and have a lot of issues. that makes us very vulnerable to these law firms, as the professor said, who have made this a business model. So welcome, Chantal, and you have the floor for 10 minutes or so. Thank you.
Thank you very much, Mariama. Welcome to all participants. I must say thank you to the South Center for the kind invitation to participate so that I can share Caricom's perspectives on this very important issue. Mariama asked the pointed question, what's going on in the region? And so I thought that at the beginning, I could just provide a snapshot of first the impact of the pandemic on Caricom. And Caricom, of course, is a Caribbean community, which is an economic organization of 15 Caribbean states. I thought as well I could speak to some of the COVID-19 related measures that Caricom states have been taking, some of which have been mentioned by Professor Sornaraja in his remarks. And then I would quickly speak to some of the possible avenues that Caricom countries have been considering to protect themselves against COVID-19 related investor-state dispute settlement claims. So with respect to the impact of the pandemic on the community, as with other regions of the world, of course, we have been impacted in terms of the number of confirmed cases. As of about the middle of this week, there were over 10,000 confirmed cases, unfortunately 243 deaths across Caricom countries. But just to go to what Mariama spoke to about the vulnerabilities of Caricom countries, it's striking that Haiti, the only least developed member of Caricom, actually accounts for almost 2/3 of those confirmed cases. In terms of the wider impact of the pandemic on Caricom countries, I'm sure everyone can appreciate that many countries in the region are highly dependent on tourism, and this sector has been severely impacted by the pandemic, and the abrupt closure of that sector for quite some time. Only some countries are now reopening the sector, will have long-lasting negative multiplier effects on the region.
Chantal, would you like your PowerPoint up? You did a PowerPoint.
I can actually proceed without it.
Okay,
I can proceed without it. Thank you. There's also been, as with other regions, a steep decline in trade and foreign direct investment flows that are projected. Caricom is actually a region that has been impacted by the imposition of export restrictions on essential medical supplies by other countries. That's a challenge that we've had to navigate. There's been immense pressure on our healthcare systems, the closure of schools, in particular, government-funded schools have severely impacted children in lower socioeconomic strata. And the closure of airport and seaport operations has also featured, as well as the impact on regional air transportation, because the pandemic has unfortunately spurred the liquidation of a regional carrier, LIAT. All of this, of course, is placing significant pressure on already tight fiscal positions of countries, many of which are very highly indebted. In terms of the measures that Caricom countries have had to undertake in order to combat both the health and the economic impacts of the pandemic, there have been measures that countries have had to take to bolster their public health systems, such as setting up of special treatment facilities. Based on my understanding in the region, these measures have not had to entail the government taking over private facilities. There have been collaborations with private entities like hotels so that their facilities can be used. But to my understanding, this has largely been done through collaborative measures. However, there have been lockdowns, curfews, and other social distancing related measures, which, as previous speakers have mentioned, clearly would have significant impact on the business community, and of course will have long-lasting effects on prospects for economic growth. Again, from the perspective of a very tourism-dependent region, the necessary travel restrictions in terms of the closure of airports and seaports, many of which too would have been to commercial travel, would have significantly impacted the region from an economic perspective. And there have been, even though many countries in the region were already operating, as I said, from a position of very limited fiscal space, there have been economic related measures such as fiscal stimulus packages that countries have adopted, whether it's tax relief measures or payroll support or support for displaced workers. And interestingly, some countries have also adopted trade-related measures such as suspension of the common external tariff of Caricom on certain essential items, or the imposition of duty exemptions on critical supplies. So the region, like other regions, has been severely impacted from both the health perspective and the economic perspective. The region, again, like other regions, has had to adopt a range of measures to cope with the health and economic impacts of the pandemic. Interestingly, coming to the focus of today's discussion and the question that would have been posed by Mariama, what possible avenues to protect against COVID-19 related investor-state dispute settlement claims have countries in the region explored? And before I get to that, I wanted to just, for the benefit of all participants, just paint a quick snapshot of the extent of participation of Caricom countries in investment treaties. It's a picture of varied participation in these treaties, and that's useful because some countries like the Bahamas or St. Kitts and Nevis don't have any bilateral investment treaties in force. And so this particular issue that we're speaking of may not be as direct, may not impact them as directly. Of course, they may be parties to investor-state contracts, but in terms of exposure to investment treaties, there's far more limited exposure where those countries are concerned. There are other countries that may have very few treaties in force, less than 10. And that actually accounts for most Caricom countries. Some of these treaties are not in force, and some of them are not with partners with which they have attracted, from which they've attracted any major investments. However, there are some Caricom countries like Barbados, Trinidad and Tobago, and Jamaica, which have concluded more investment treaties. These are countries that have signed more than 10 investment treaties, some with important trading partners. And for those countries in particular, this is a very live issue. And so essentially, this issue has attracted the attention of trade ministers in the community. We have had discussions at that level about possible exposure to COVID-19 related claims. And those discussions have taken place within the broader context of discussions on investment treaty reform, which I'll come to towards the end of my remarks. The community has been considering some initiatives which have been piloted by, for instance, the International Institute for Sustainable Development. They have, for instance, brought to the fore the possibility of countries, whether it is through a multilateral mechanism or a bilateral mechanism, agreeing to the suspension of investor-state dispute settlement with respect to COVID-19 related measures. Now, of course, this is a more targeted type of initiative than some of the broader investment treaty reform initiatives that Professor Sornaraja would have mentioned, such as termination of investment treaties. But we have looked at the notion of targeted suspension of investor-state dispute settlement with respect to COVID-19 related measures. Recognizing, of course, that a multilateral initiative is more far-reaching, will take more time to come off the ground. What we have considered is countries that consider that they might have particular exposure to through particularly risky treaties with individual countries to consider pursuing suspension on a bilateral basis, pending the adoption of any multilateral initiative. The IISD has also highlighted the possibility of countries, particularly those that are party to older generation treaties, thinking very carefully about the kinds of defenses that they might be able to mount. You know, Professor Sornaraja would have noted that some treaties, not all, may have reference to specific exceptions, whether they're general exceptions or they're the security exception. But of course, there are defenses which countries might be thinking of mounting by reliance on customary international law, such as the defense of necessity. And it has been pointed out that this has proven to be a fairly difficult defense to mount because of its interpretation as one that requires the defendant, the respondent state, to essentially demonstrate that the measure that they took was the only one available to them in the circumstances, and that to take. And that can be a very high threshold for countries to meet. And so one suggestion has been that countries can think about concluding joint interpretations regarding this defense that would clarify that government should be considered to be acting in necessity and not in breach of their treaty obligations when they take measures such as the ones that I've highlighted to combat the health and economic impacts of the pandemic. Professor Sornaraja has already mentioned the notion of withdrawal of the offer to submit to arbitration. Again, countries, I think, can think about withdrawal of consent, perhaps in the context of broader reform of their investment treaty program or in a targeted way. Again, the notion is that I think countries have the options based on their particular circumstances to use this opportunity to think about broader investment treaty reform or to adopt more targeted measures that they think might be suited to deal with claims that they think that might arise from COVID-19 related measures. UNCTAD has put forward or recalled an important consideration that countries should be thinking about, and that's the notion of dispute prevention. And I'm not suggesting that dispute prevention is some kind of panacea, but to the extent that there are measures that countries can take, whether they're early warning measures or any other kind of institutional mechanisms that they otherwise would have put in place to be alerted quite early to the potential for disputes. These are mechanisms that they should be actively utilizing at this time. Now, I wanted to just end by speaking more broadly about the opportunity which this pandemic presents and the discussion that we're having about the potential exposure of countries to investment claims presents for countries to focus on the broader issue, which has occupied the global community for some time, on investment treaty reform. And this is an issue which in the community, we have been looking at. Only in November of last year, we staged a forum on international investment agreement reform. And it was a forum which was heavily focused not just on the forward-looking issue of how countries should approach the negotiation of such treaties in the future if they opt to, but more importantly, what are they going to do with the existing stock of agreements that they have, many of which, from the perspective of Caricom countries, are older generation agreements, which are extremely broad in scope, have very broadly worded standards, actually don't have written explicitly in them any of the exceptions that we are talking about right now, do not have clarifications of standards which have been referenced by Professor Sornaraja, like expropriation, no clarification of whether indirect expropriation is covered and what constitutes indirect expropriation, no clarification of the standard of fair and equitable treatment. no exceptions to obligations like free transfer of funds. So again, providing guarantees to investor-state dispute settlement in circumstances where the mechanisms are not circumscribed. So we're very much focused on this issue, this broader issue of investment treaty reform, and with particular focus on hard decisions which countries have to take about what they're going to do with their existing stock of treaties. This requires countries to engage in assessments of the risks, the costs, the perceived benefits that these arrangements generate for them. What became apparent through the forum that we had is that many officials are frankly not aware of the contents and the implications of these treaties. And so assessing the risks, assessing the costs and their benefits, and then in light of the outcome of that assessment, taking very tough decisions about what courses of action they're going to take with those treaties, ranging from issuing joint interpretations to, as Professor Sarnarajan mentioned, termination of the treaties, abandonment as well of treaties which have been signed but have not entered into force. As I mentioned, quite a number of Caricom countries we found have actually signed treaties but never taken actions to bring them into force. Concerted action can be taken with respect to whether countries want to simply abandon these treaties that they have not ratified or otherwise sought to bring into force. And of course, there are
2 more minutes, Chantal.
Oh, okay. I'm certainly going to end before that, Mariama. Thank you for that. And there are decisions that they have to take as well about whether they want to renegotiate, whether they want to embark on any renegotiation of these older generation treaties as well. An important discussion, an important consideration that we're realizing that our countries have to engage in are discussions about whether there is a need for them to continue to negotiate investment treaties. There's a knee-jerk reaction, which is often made, especially in the context of engagements that countries might be undertaking on broader economic partnership countries. And there is a tendency to assume, well, part of that discussion on an economic partnership or a trade agreement has to be a companion investment treaty. Mm-hmm. Countries really need to examine in a very concerted way whether there is a need to have investment treaties as an extra layer of protection to investors over and above what is available under domestic law, what is available under any targeted investment contracts that they opt to conclude. And so just in sum, to answer the question that was posed directly, even though there is varied participation of Caricom countries in investment treaties, as I said, ranging from countries that have no bilateral investment treaties in force to countries that have been more active participants in investment treaty negotiation, the community understands that this is an issue, potential exposure of some countries to these types of claims that has to be confronted. There are a range of options which have been explored, some of which are more targeted in nature and might be more time-bound in nature. But I think what I would want to emphasize is that the community is attaching more broadly importance to the wider issue of investment treaty reform, including with respect to the existing stock of treaties that countries have concluded, and they are also focused on moving forward questions relating to reform with respect to the future negotiation of any treaties that countries may be thinking of concluding. So thank you.
Thank you very much, Chantal. Very comprehensive and a really good painting of what's going on. And you've identified another vulnerability for me that I hadn't thought about, which is the vulnerability of the Caricom nations, because there are so much of the treaties, or the older treaties, with all these vague provisions and other dimensions of that. I have many questions, but I won't go there because we need to move along very quickly so we could have some discussions. I flagged some things that I would like to come back to as part of the general discussion. But I'm going to move now to Rosalind and ask Rosalind to please welcome. It's great to have you here. African perspective in the house. Lovely. So Rosalind Njeno is a senior investment expert in the Department of Trade and Industry of the African Union Commission. And I'm sure you do a lot more than that. So please speak to that when you're ready. My question for you is, what has been the experience of the African Union regarding the current state of regional efforts for investment reform and the various investment related measures taken in the wake of the COVID-19 pandemics by African Union member states? Did you get all that? I have to repeat. You're muted. Okay.
Yeah, thank you. Thank you very much, Dr. Mariana. And I want to take this opportunity to appreciate South Center for inviting the AU to this important meeting and to answer the important question that has been posed to us, what we have been doing with respect to reforms in the investment field. First of all, as you may be aware, we have signed an agreement called the AfCFTA, the Continental Free Trade Area. This was signed in 2019 by 54 member states. And one of the protocols that was agreed to be negotiated was the investment protocol. The investment protocol is an indication. The negotiation of the same is an indication that Africa is moving towards reform, and not only through the investment protocol. When you see the landscape of the latest treaties that African countries have negotiated and signed, they are actually reform-based treaties. And if anything, they have become trendsetters in terms of new innovations or innovativeness in addressing the issues that affect developing countries and particularly African countries when it comes to the threats and also the advantages. How do they want to benefit from the investment treaties? Now, with the question of COVID-19, and as has been mentioned, African countries are continuing to act to curb the spread of COVID-19 through emergency interventions, such as shutdowns and strict containment, and measures to ensure supplies of essential foods, medical equipment, and healthcare services. Shops, factories, airlines, mines, you name it, other businesses are all drastically downsizing or halting operations due to emergency regulations. Some governments have put curbs on exports of medical supplies and medicines. Caricom has indicated to us that this is what they're also doing, and other countries are doing the same. And even Professor Correa has also given us a brief on what countries are doing. At the same time, African governments are taking emergency measures to address the economic and financial impacts of COVID-19, with many of these emergency measures hitting hard on businesses. There is, of course, this risk that has been presented to us. In light of this, AU provided its member states with a unique platform to deliberate on the concerns that have been flagged out and that may have the potential to destabilize our countries economically. Just for noting, keep in mind that African states have concluded more than 800 investment treaties or treaties with investment provisions. Of these, we have about 189 intra-African treaties. So the AU, under the Directorate of Trade and Industry, and based on its mandate to provide policy guidance and advice, and given that we have not yet negotiated the investment protocol, initiated the discussions and coordinated with experts. Some of the experts are present in this panel today, They initiated these discussions to conceptualize issues around the potential threats that may be posed by the investment treaties Africa and indeed the world has signed. One immediate activity undertaken was a discussion by ministers on the way forward on this threat. So in one of the joint bureau meetings where the ministers met, the ministers for trade, AUC presented a paper to the ministers on the imminent threat. And the ministers noted that there is need to preempt these potential arbitrations. They further observed that there was need for a collective action on this matter, and thus directed the AUC to prepare a language on the proposed measures for consideration by member states. Some of the discussions that came out during that meeting and a subsequent meeting by member states to just discuss these concerns were some of the areas that have been pointed out by Professor Sonaraja, who has my highest respect. He's one of the greatest experts in this field of investment treaties and reforms. So AU has drafted some proposed language to these measures. However, this is yet to be presented to member states for deliberation. The purpose of the language is threefold. It is intended to raise awareness of COVID-19 related ISDS risks among member states. It is to identify concrete actions that member states can choose to take to address treaty-based ISDS risks. And thirdly, to give moral and political support to member states in taking these actions. The policy actions are centered around the principles of cooperation, multilateral action, and the proactive exploration of options for mitigating ISDS risks. We need to keep in mind, though, that the document does not attempt to address broader concerns or risks relating to ISDS more generally, which are currently being discussed in various international and regional fora. It is also limited to addressing ISDS risks arising under investment treaties, and it does not address similar risks under investment laws or contracts. So you can see that there is a step that the AU has taken, having a vantage point and an advisory point to member states to say, let's discuss these concerns and let's come up with solutions. And so these are things that we are still discussing. They're still under consideration by member states. And we're still trying to find the best way forward. I will stop here and await your comments and questions. And I thank you once again most sincerely for your kind attention. Thank you.
Thank you, Rosalind. Thank you very much for update and bringing us aware at the level of intensity of the discussion in the AU and among African member states. I think you also flagged something that we need to come back to discuss this again, the idea of collectively responding or collectively having some joint interpretations, which seems to be a common theme so far in the discussion. All right, as we're want to make sure we have enough time for discussion, I'm actually going to move quickly to Claudia Salgado Levy, who is the National Director of International Affairs in the Office of the Attorney General of Ecuador. So we're moving to Latin America. We had Africa in between the Caribbean and Latin America. So now we're back to Latin America. So Claudia, what role have state mechanisms and institutions played in coordinating a national response to international investment dispute related to COVID-19 measures, including aftercare and prevention of investment disputes?
Thank you.
That has been on the firing line in this discussion, so lovely to hear from you.
Thank you, and thank you also for the South Center for the invitation. Thank you to Mr. Carlos Correa, the Executive Director, and also Daniel Uribe as the Program Officer. For me, it's a great honor to be able to share some thoughts on this issue. And as you requested, I should speak about how the state can deal with investment disputes which may arise from the COVID-19 measures. As it has been said on the title, the first mechanism is definitely cooperation and coordination between state entities. And maybe this is even the most difficult task. And all the governmental officials who are listening to me now may agree that entities usually conduct themselves like islands. They consider themselves very autonomous, independent, and it is therefore very difficult to coordinate among themselves. So the coordination has to be made at two levels. First, to prevent investment disputes, and second, to defend the state once the dispute has arisen. So I will develop very quickly these two topics, two ideas. Regarding the prevention of disputes, now that countries are adopting some measures to face the economic crisis as a result of the COVID-19 pandemic, they have to coordinate amongst them in order to raise awareness of what has not to be done or should be avoided to do. For instance, states have to avoid making public declarations that would compromise the international responsibility of the state. So, for instance, some states that we call populists like to go out and make some declarations. And these declarations could be interpreted as acting against one company, one sector, or one investor. So states have to avoid making declarations against some individuals. The second point is that due to the pandemic, some states have adopted taxation measures. And the taxation measures are adopted in order to put some burden into some companies which are doing better than the other ones. So in this case, states have to be very careful not to adopt any discriminatory measure, or not to adopt any measure which will distinguish between nationals and foreign companies. All of them have to be treated alike in the measures that states adopt due to the pandemic. Likewise, when we talk about importing and exporting measures, states have to apply similar standards to the entry and to the exit of products. And something that has arisen very criticism, for instance, is when it comes to allowing or denying some business activities to be reopened. As we all know, due to the pandemic, many businesses have been closed, shut down, because the state has requested to shut down for public purposes. But this has to be motivated decisions, and they cannot be discriminatory or unfair. So we have had the case very much business activities complaining that the state has not thought on the medium term, but the state has taken one decision for 1 week, and next week they have changed the mind and take another decision, and 2 weeks later, knowing that the pandemic is still bad, have gone back to another decision. So these aleatory decisions cannot be taken. They have to be planned with time. So the business activities can restructure themselves according to what is planned. Also, something that has arisen very much now is the debt restructure that I know Liz will talk, so I'm not talking about this. But just one thing that we have seen is that in this case of renegotiating the debt, state has to negotiate with all the shareholders of the bonds. So this is something that has to be taken into account, and not just to negotiate with the majority of the shareholders, but to try to reach an agreement with all of them. And finally, I think this coronavirus has taught us that it is the time to renegotiate. In the case of Ecuador, we don't have any more BITs, but we have state contracts. And it's the time to renegotiate all these state contracts, concession contracts, and to include some clauses that will contemplate future situations such as the one that we're living now. So it is necessary, for instance, to include one clause that will be able to make exceptions to stabilization clause, or any other clause that will allow force majeure to come into play when these kind of things happen and the state has to protect public interest. So this is something very important that state entities have to coordinate in order to renegotiate all the state contracts they have signed. I think this is the good moment to do it. I'm going to my second point regarding the management of disputes once they have arisen. If something has taught us this pandemic is that electronic means are very important. From now on, we should give priority to digitalized means of doing things. And even if this seems silly or not important, we have to take into account that once the state is sued into an arbitration, it has to collect all the information regarding the dispute. And in order to collect all this information, it has to coordinate with different state entities. So if the state entities do not have all the information digitalized, it is very difficult to prepare a case. So we have a lesson learned, which is that all the public entities have to keep a digitalized system of all the information, which will be the basis for defending the case. Also, one thing that people maybe should be aware of is that, as you know, investment disputes are very specialized. So once a dispute arises, the state usually has to hire external counsel. But the question is how to hire a lawyer from home. If all the system is shut down, if the public sector is not working, if everybody's working from home, how do you hire a lawyer to defend the state? And in this particular issue, we have to take into account that many applicable rules in the arbitration contain an emergency arbitrator. If there is an emergency arbitrator, the possibility for the state to react is very short. So within few days, the state has to have all the case done to argue in front an emergency arbitrator. This is not possible to do if we don't even have all the system properly working, and worse, even if we are working from home. So it is important for states to consider not including emergency arbitrators on the disputes. I know that the London Court of International Arbitration rules have this emergency arbitrator, and I know also the ICC counts with that one. So states have to make sure they will exclude the possibility of going to an emergency arbitrator, because experience has shown that it is very few time for reaction from the part of the states. So this is again a good opportunity to think about processes that have to be simplified. Not only processes that have to be digitalized, but we have to simplify processes within our internal entities. And finally, another concern in order to defend or manage an investment dispute is the production of proofs, the production of witnesses and experts. This is also something that requires mechanisms to coordinate between public entities in order to select the most appropriate witness or expert. So this is again a proof that the coordination has to be continuous between public entities. And even if it seems easy to do it, it's the most complicated thing because, as I told you, entities work like independent islands. So I would like to stop here and give the floor for all of you in order to get some questions and to deep in any topic that you would like me to do it. Thank you very much.
Thank you, Claudia. Thank you so much. And you've saved us a couple of minutes off your presentation, but your presentation was so rich. I mean, I think you introduced some new dimensions that haven't come up before, the whole idea of the taxation measures and the discriminatory or potential discriminatory effects on different company, likewise for export. But also you talk about, again, another dimension that many governments have, which is in terms of allowing some businesses and denying other businesses, and how those pre-propose them or predispose them to certain kinds of charges and so forth. So a lot of things that you've put on the table, I hope we can have some time to discuss. Sounds like we might need another discussion set up. And then again, the whole question of you also propose are thinking ahead to what states may want to put in future clause in terms of these emergency arbitration, and how that now is a lesson that we'll learn. Nobody expected a once in a 100-year pandemic, and that state has to quickly react. And we already have a system that's against the state that has an emergency process built in, which is something I wasn't aware of. So that's a new learning for me, and that's pretty interesting. I'm going to move now to our last presenter, but not least, because she's coming with some pretty powerful things. Dr. Lise Johnson, Head of Investment Law and Policy at the Columbia Center for Sustainable Investment. Also our partner. People have been saying a lot about South Center, but the Columbia Center has been the partner in helping us to organize this, and really want to thank you, Lise, and your teammate, and welcome. And we're looking forward to hearing more about the center and about what you're doing. I do have a question for you also. Could you provide an update on the recent call for ISDS moratorium during COVID-19 and a crisis response issue by CCSI and other eminent persons, including South Center, and what response has it received? So
Great.
Again, I'd like with others, I know you're doing a lot more than what my one-line bio says, so please free to add.
No, thank you so much, and thanks for the invitation to speak, and that's the opportunity. It's really terrific to join you, and I'm sorry that I am now standing in the way between Q&A with, I've seen already great questions coming in the Q&A box, so hopefully we'll get to those soon. I will try not to take too long. I wanted to provide a little bit of a background on the moratorium, the call for a moratorium and restriction on ISDS claims for those of you who maybe not familiar with it. And then also give a little bit of an update on what has been happening since we issued that. So in terms of the call for a moratorium, in May, we had issued this 2-point call. One part is a call for a permanent restriction on ISDS claims, and then a temporary moratorium on ISDS claims. So the permanent restriction is on COVID-related claims, and the temporary moratorium would be on all ISDS claims. And this call was issued together with over a dozen eminent thinkers across roles, geographies, and disciplines. And I'll refer you to the website for that call, the text of it, as well as the signatories, so you can see it. You can see it there. And I'll just update a little, provide a little bit of background on this call. So why then a permanent restriction on ISDS claims related to COVID-19 measures? We identified 4 reasons why we thought that this was important. The first was to avoid inequality exacerbating distortion. So the business closures and the other emergency responses that were adopted to deal with and are being adopted to deal with a pandemic and its associated effects are creating unprecedented and far-reaching changes to the business environment and also to the human environment, leading to lost profits and lost income. So it's requiring widespread relief and will require widespread relief to companies and people. But ISDS in this context only provides special relief for certain international investors, which is something that can distort support schemes and potentially divert governments' resources and attention from the needs of individuals and real economic actors on the ground. And then the second reason that we thought the call was important, the moratorium was important, is to mitigate the economic impacts of the crisis. So ISDS awards to investors, as we know, they frequently total tens of millions of dollars, not infrequently in the hundreds of millions of dollars, and can even stretch into the billions of dollars. And claims, particularly when a government faces multiple at a time, which is something that could happen with a measure that kind of reaches across a wide sector of the economy, can represent sizable percentages of the budgets of respondent states. So these legal liabilities can weigh heavily against the budget crises that will face governments in the context of the COVID-19 pandemic. And even without legal liability, the litigation alone is costly, averaging about $5 million per case to defend. The third reason is to avoid regulatory chill. I think the mere threat of suits could chill the taking of crucial and timely regulatory or other governmental action. And governments, we think, must be able to fulfill their highest duty of protecting their citizens, halting the spread of the pandemic, and avoiding economic disaster without fear of facing ISDS claims. And fourth is in recognition of the view that ISDS is not currently suitable as a mechanism for resolution of the types of public interest claims that can be brought under investment treaties. States have agreed in the process ongoing at UNCITRAL, the United Nations Commission on International Trade Law, that ISDS is fundamentally flawed and that systemic reform is necessary. So in that sense, it doesn't seem to make sense to continue to subject states to ISDS while reform is ongoing, with its recognized problems of inconsistency and incorrectness, unduly high costs and long duration, concerns about the quality, independence, and perspectives of adjudicators, and other cross-cutting issues such as the risk of regulatory chill, of problematically large damage awards, and the inappropriate sidelining of domestic courts. And I think one thing to keep in mind is in terms of the reaction, which I can come to later, we've seen a lot of positive reaction, but then some of the negative reaction has been, well, you're calling for a world without government accountability. You need ISDS for government accountability. And I want to be clear that that is definitely not what we're calling for, that we think that government accountability is crucial. But what we think is that there are other kind of less flawed, less risky, less costly, less distorted ways of addressing issues if states or other stakeholders consider that there has been an abuse of rights or breach of law. So I think that goes back to Chantel's comments too about assessing what is provided for domestically and whether or not you need something internationally. So we can consider then the role of domestic courts, risk insurance, state-to-state mechanisms, and human rights claims. So there are other ways, even if you take away ISDS, that doesn't mean that you're leaving investors without recourse. Then why a temporary restriction on all claims? This is the second part of the call. You pause all ISDS claims. And that is just that states and the stakeholders don't need this diversion of time and resources. The fact that awards are not tied to states' ability to pay, nor even to amounts invested. So I think that channel of increasingly scarce public resources to private interests is something that we really need to think about critically now. And as Claudia was just highlighting too, the actual challenge of litigating these disputes is huge at the moment. You've got situations when timeframes and circumstances of the attorneys and the arbitrators who operate in places like New York and London are very different from the timeframes and the circumstances of respondent states. And so the actual challenge of managing these cases at the moment is huge, I think. And then what I think is a crucial consideration, again, is just the fact that the system has been recognized as being fundamentally flawed. So it doesn't make sense to continue to arbitrate disputes while the governments are under kind of extreme strain at the moment. So the aim of the call was to articulate this issue and its overarching aims, but we left for further discussion some technical issues and policy questions in terms of really how to implement it. So a few of the questions that are not answered by the call, but I think that are important to think through, is whether governments really want to focus only on COVID-related claims and a permanent restriction on those, or again, kind of address all claims through either a temporary or longer measure. If focusing on COVID-related claims, then the question is, well, how do you define those and who gets to decide? And there have been some really good efforts to think through those issues in connection, for instance, with the proposal for the suspension text that ISD has advanced. Then another question is, if the restriction is for all claims, then when might that restriction be lifted? States could tie it to a specific duration. They could tie it to achievement of a future agreement or a future agreement to resume, or they could tie it to certain conditions being satisfied. And one thing noted in the call is that it could be that claims could be resumed once there is a kind of sufficient agreement on principles for addressing damages. So that is another kind of set of open questions of when you would resume a temporary moratorium. Other sets of questions relate to how to then link steps here with broader priorities for reform. So there's, again, kind of echo comments made by Chantel and Rosalind and Claudia, in the sense that if we're focused on this, how does it overlap with, and how do we make sure it doesn't undermine broader reform efforts? How do we make sure we're not missing potential opportunities for connecting the two? So those are, I think, some important considerations. And then in terms of what's next, as I said, there's been a lot of attention on the issue. The number of hits on our website has been among the highest. There are a lot of people checking out the call. There's been a lot of informal inquiry by states and by other stakeholders. It's been picked up by the media. It's been picked up in key publications like UNCTAD's World Investment Report. ISD is also advancing work on suspension and has a draft text on its website that can be considered either bilaterally, plurilaterally, or multilaterally for that. And then as I think Sonia put in the chat, there was a letter signed by over 650 civil society organizations that articulate 6 steps that government should take that also kind of corresponds with the recommendations in the call for the permanent restriction and temporary moratorium. I think we're also seeing these issues, actually interestingly, percolating among home states. There was a question by a UK member of parliament to the UK government asking what the UK government is doing to prevent its treaty partners from being subject to COVID-related claims. So I think that these issues are definitely spreading. Awareness of the issues is spreading, and more thinking about what the next steps are. So I would say in terms of next steps, I guess the place for action is at the domestic level to a great extent by identifying for governments what the risks are, what the options are, what the priorities are, and understanding that the menu of options is really wide and includes any of the 10 options identified by UNCTAD as part of phase 2 of reform, including termination, and also just to flag that we, together with IISD and IAED, had proposed a multilateral convention on termination in connection with the UNCTAD reform process that could be used as a way to kind of clear the deck and get rid of some of these old treaties at a multilateral basis. So those are, I think, some of the next steps, but I think it's important to understand what could be done by each state domestically, unilaterally, bilaterally, regionally, multilaterally, and what the advantages and disadvantages are of different approaches depending on, the treaty. It could be treaty by treaty. So I think considering those issues, going through those issues at the domestic level, and then thinking about potentially you might want to phase approaches, combine them. So I think it's not necessarily that one solution will fit for all treaties or all treaty partners, but it might be important to think about how to use different approaches depending on the treaty, and maybe try something. If it doesn't work, then try something else. So that's kind of where we're at, but if there are more specific questions, I can try and answer them. So thank you again for the opportunity to weigh in.
Much. You're very efficient with the time. We have some time for questions and discussion, but I really liked how you presented, talking about the problem with the system at a systemic level, why it is that a moratorium is put on the table, and also talking about trying to address some of the negative claims. Some are quite inflated, some are around why this is. But I also thought the questions that you raised about what the moratorium doesn't address, and the question that it leaves for policy space for us as activists, advocates, governments, inside multilateral departments, inside our bilateral department to discuss and put forward over time, is really a good food for thought. So I want to thank you all. I mean, this has been a really great panel because each of you have overlapped some a little bit, but also brought out more discussions, more flavoring, more nuancing of this very tendentious and troublesome subject that's really have serious implication for the lives and well-being of citizens in all of our countries. So thank you very much. And I thank the professor for his broad palette, and also he dug deep in the 6 alternatives. So now I want to shift a little bit and go into the chat and the questions. There are a few of them. Some of them are pointing out there's Sania's bringing to attention the call by the over 600 CSO for presenting that, and there's a link to that, and I'll ask different people to voice their own presentation. There was a question about Dr. Chantal's idea of a joint interpretation of the defense necessity. Are any countries in the Caribbean region actively considering this, and what might be the content of such a declaration? So I'll just throw that out. So Chantal, I know you've been looking at the chat, so you could think about that a little bit. And then there is a link to visit invest.go.ken that I hope people know what that is. I'm not sure what that is. But let's start with Chantal and this joint interpretation. And Daniel is also, Danish probably is also looking at some of the questions. If I'm missing anything, please let me know.
Thanks, Mariama, and thanks to the person who posed that question. The direct answer is I'm not aware of any countries in the region which are actively pursuing the use of a joint interpretation. What I can say is, I think it would be most relevant to countries that have concluded that they are quite exposed to the risk of cases. As I said, there are countries in the region that don't even have any bilateral investment treaties in force. I think for countries that assess that by virtue of the agreements that they are parties to, the nature of the content of those treaties, particularly the old generation treaties, as I said, that don't really feature clarifications or even feature these types of exceptions. They're probably the countries which are most interested in pursuing such a measure. In terms of the content, the possible content of such a joint interpretation, we haven't looked at specific language, but I think the core of text of that nature would really be to clarify that when countries are taking measures of this nature, they are acting in necessity. Essentially language that would dispel any argument or any possible interpretation that a country would not be deemed to be acting in necessity if there were alternatives that were reasonably available to them that they could have pursued, which is in many ways the hallmark of such a defense. You're only deemed to have taken action that was necessary if there were no other options available to you, or there were less restrictive options that were reasonably available to you that you didn't pursue. So I think the core of such a clarification would be expressing the government's view that, collective views that they would have been acting in necessity by virtue of the situation that they had to be responding to. Thank you.
I'm going to ask Robert, UNCTAD, Diana Rossert, are you there? If you would like to pose your question very quickly, and then followed by Robert Berry. Yeah. Remember to unmute yourself. Are you there, Diana?
Yes, I'm there. Sorry, you hear me?
Yes, yes, we could hear you loud and clear.
Okay, my question is that some proponents of the current system have emphasized that there have been no COVID-related claims actually launched already against states under IAAs. And there may be reasons why, and could maybe the panelists address some of the reasons how long it takes to actually initiate a claim, notice periods, and so on.
All right. And Robert, would you like to pose your question? Then I'll go back to the panel. Are you there?
Yes, can you hear me?
Yes, loud and clear.
Okay, thank you. My question was just that in the area of investment promotion and protection, the whole career, the issue of virtual investor conferences, virtual investment promotion missions. I wanted to know from the panelists, how is that approach being taken up? Is it successful, and what basically needs to be done to improve the same? Thank you.
Okay, so I'm going to ask the panelists to talk about the question of maybe that there are cases that they haven't trickled out yet. How long does it take? And why do you think that there hasn't been any? And then Robert's question about the virtual conference. Anyone, please, would be interested in tackling that issue? Yes, Lise, and then Professor Lisa?
Yeah, I can weigh in really quickly on why, I mean, some of the reasons why, I'm not sure why we've seen claims, or some of the reasons that could explain that. One is that we might not know that they would start with a letter to the government indicating that there might be a claim if the government doesn't do X or Y or does X or Y. And so those are things that we likely wouldn't even see. So that could very well be happening. Another reason is that there's no statute of limitations in many of the old style BIT, so there's no requirement for a claim to be brought within a window. It can come 10 years from now. And then there's no then incentive necessarily for an investor to go ahead and kind of jump the gun early, unless it's trying to use it as a threat. But there's no real incentive for it to file that claim earlier, because it can sit there and amass evidence, start collecting bits of evidence about what the government has done in X or Y or Z circumstances. So when it's ready to file its claim, it does so with all of that preparation with it. So I think that the fact that we haven't seen any now doesn't mean anything, especially since so many of the measures are economic and not necessarily health related.
Professor?
Yeah, the investment arbitration report, which you can read only if you have a lot of money, but my university subscribes to it, notes that there are two cases, one against Zambia and another against Venezuela. So the cases would obviously begin. But I think most of these cases would involve claims that are brought in order to pressure negotiation. That would be the strategy that most investors would use in order to get exemptions from the application of COVID-related measures by states. So they may not want to pursue the claims to the full extent, but bring them in order to negotiate for advantages. I suspect that's why we haven't seen actual papers relating to these claims. I also want to make a point about necessity, if I may. Mm-hmm. Necessity is a defense that's in general customary international law. One doesn't sort of pick it up from any treaty as such. So the question of joint interpretation would not arise from within the treaty itself. So the plea of necessity is stated in the Code on State Responsibility, a draft code of the International Law Commission. And of course, unfortunately, I believe that it states wrongly that if there is an alternative, you cannot use necessity. I mean, necessity is something like self-defense. You can, you always have the necessity, you always have the alternative of running away from your attacker. There's no requirement that you should stand and fight. So this statement in the ILC code, I think, is too favorable to foreign investors. Yeah, that's my view. Thank you.
There's another question about this issue of collective action. What form might it take? Is there multiple forms, and what could be effective? Would collective action help in the case of the old generation BIT? This is from Begani Esenkulova.
Yeah. Well, if I may, I mean, I don't want to monopolize this, but in the case of the two experiences we have of the three experience of South Africa, India, and Indonesia, they terminated each treaty by treaty. I don't think that that the multilateral convention would suffice because of the fact that most of them are bilateral relationships which would have to be terminated by unilaterally, perhaps, as I suggested, or with consent of the other party. Thank you.
Okay. Chantal, about the older bits in the Caribbean, would collective action apply to those or be useful in any way?
I actually think that it would be useful for countries on an individual basis to assess the content of the respective treaty and then to take decisions based on what they perceive the risks or benefits of the treaties to be. In the case of Caricom, there isn't a lot of overlap. First of all, there are no intra-Caricom bits, for instance, that a collective arrangement might, for instance, be relevant to. Most of the treaties in question are concluded by the individual countries with external partners. And I would predict that there might be differing conclusions reached by individual countries with respect to what action they think is relevant. And so I really think that that kind of individual assessment about the risks and the next steps really would be priority.
Yeah. Rosalind, and you mentioned also within the AU the idea of some collectively thinking about some of this. how would you see that working out, and possibilities and constraints?
Thank you. And just following from what Chantal has indicated, it will be useful for countries to actually assess the content of individual treaties. But for Africa, for instance, data by UNCTAD indicates that we have over 180 intra-Africa treaties. So because of the existence of those intra-Africa treaties, then it is possible to actually come up with collective action. Now, the collective action would be in this time and point would be, we need to take things unusual because we are dealing with circumstances that are also unusual. And countries are taking measures. They are not looking at anything else except saving lives and managing the pandemic. So this is unusual. So therefore, the collective action that they would take would take, I don't know, maybe the form of a declaration to say, we understand that this matter is affecting us, and therefore we would want to say that anything coming up or coming out of any case coming out related to COVID measure should not be addressed, maybe something like that. And this is something that can be done by all the countries that have this single interest. So in this case, Africa would be a good example because they have intra-Africa bits amongst themselves, and they are facing almost similar challenges when it comes to the measures that they're taking. So it is possible to take this. However, they need to then look at what works, what will work. If we say we are addressing COVID-related measures, how would they address it? So that is a question that they would need to discuss, and I think that is what they would be doing in the near future. So that's my take on that.
Okay. Claudia, Latin America, but you also made the point earlier when you started about the differences among entities, and these are domestic entities, but also among countries. So what are the scope and relevance for collective action or any other things that you think from the regional perspective of your region? Because you're on the front line so far.
In fact, it's very interesting. Latin America was trying to make a joint declaration in order to request ICSID, for instance, to take into account this situation, to suspend or to take some actions, because things are still going on, proceedings are still going on like nothing has happened. And for the state, it's very difficult to defend itself in this current situation, working from home, working without all the instruments, working with many limitations. But unfortunately, each state has its own interests, so it's much more difficult to coordinate, but it's a good idea. And I'm sure the states will end up coordinating, and this is very important. But until now, it has been very difficult to have a clear text with clear wording that will benefit all the states and will not prejudice in one of the cases, because any state wants to say something that could be used against it in a trial. So we have to be very careful, but definitely it's very important to coordinate in a multilateral level, in state, regional level.
Okay, great. I think you've all been very good, so I won't even try to summarize, but I beg the patience of the participants, and you've also been here 10 minutes more than we had projected. But I'm going to give you each 1 minute to say a last word or whatever you'd like to say. And Danielle and Dr. Correa, if you would also have anything that you might want to say as we sign off. Now we're going to go a little bit over. Yes?
Can I start? Or?
Yes, sir, please.
Okay. Thank you. I liked Rosalind's presentation about Africa. But my concern with Africa particularly would be that many of the African treaties are not ratified, so treaties may not pose that much of a problem as would state contracts. There are far more state contracts that are made in Africa, particularly in the natural resources sectors. And I think that the violation of some of the terms of those the provisions in these state contracts would be something that would cause a great deal of concern for the African nations. As far as treaties are concerned, the African thinking on these treaties is very innovative. So if you look at the ECOWAS investment code, for example, it says that all treaties that are inconsistent with the provisions of the ECOWAS code should have to yield. So it gives priority to the ECOWAS code. And of course, there's a Pan-African investment code as well, which is also new and which incorporates many of the ideas of sustainable development and preserves regulatory space, provides a series of defenses. So these are innovations, but ideally, of course, from my point of view, there should be no such treaties. But nevertheless, if there are to be treaties, we have to be conscious of the fact that there are defenses provided, like in the new African treaties, and we must be concerned equally with the way in which law is created for state contracts. Thank you.
Thank you very much, sir. Lisa, you didn't get around before. Would you like to? Are you still there? Yes, you are.
Oh, yeah. Yeah, I mean, I think maybe one is that with a little help from colleagues too on this who are on the call and who've been thinking about these issues with me, is that it's going to get worse before it gets better. I think the issue of COVID-related claims and also the economic fallout from COVID and also the health-related fallout from COVID. So I think it's important to consider these issues now. So it's great that you're doing this. And that it's also important to really link this with considerations around systemic reform. And I feel like we have a window of opportunity now because there are a number of capital exporting states who had been primary drivers of the system who are also reflecting on the system and moving away from it in certain contexts. So really kind of trying to seize this opportunity and be reflective and think about the ways forward. Thanks.
Great. Thank you very much. And thanks to CCSI for its work on this issue. Now, let's see. I'm going to go to Claudia and then end with the Caribbean. Claudia, any last words?
Mariama. I think we should take this as a lesson, what has happened and what is happening. And the lesson is that the sovereign power to regulate for public purposes, such as health issues, should not be limited. And therefore, states have to preserve their right to regulate. And they have to consider that when negotiating not only investment treaties, but also state contracts. And in any arbitration clause they will put in any contract, they have to always keep space to regulate for purposes. And of course, we can use a terminology to say not in a discriminatory manner, in similar circumstances, to avoid any arbitrary measure. But it is important for states to have this power to regulate, because this is what we have seen in cases such as this one that we hope they will never repeat again.
And that would be the capstone that I think for this is the states preserving their right to regulate. Chantal?
Thank you. I would just end by underscoring the need for states to take very seriously the obligations that they undertake in these treaties, that they take very seriously the power that they have to even revisit the agreements that they've already concluded, the power that they have to revisit whether they're acting in, whether these treaties are serving their interests, and the autonomy that they have to take steps to remedy the situation if that they are not in their interest. Thank you.
Yeah, Rosalind, did you have anything to say, last word? And then I'm going to ask Professor Correa and Daniel if they had any last word on this. Yes.
Thank you. And we have had very useful interactions today from all corners of the world. What we are realizing is that the situation we are in right now, it is still extremely fluid. We do not know what works and what does not work, particularly with the pandemic and the measures that the countries are taking. So 2 key things to take home is we need to raise the awareness. when you discuss with government, some government institutions, the awareness is not there that whatever countries are doing for public good is actually a recipe for arbitration, ISDS. So it is not, the information is not yet out there. And yes, governments still need to undertake their rightful regulatory measures to ensure that the public is protected. And they also then need to look at, because they need to look at the aspect of protection of this, they need to look at potential solutions. So that is something that needs to be driven from all parts of both academic, government, civil society. It needs to be driven home so that all these discussions we are having today get to the policy decision makers. So that's the point I want to leave with you. Thank you
very much. Professor Correa, is there a last word that you'd like to say, sir?
Okay, well, thank you very much. It's been an excellent debate. Thank you very much for your presentations. What has been said in these webinars just confirms that this system needs a very deep reform. So we need to continue working together in order to ensure that this very special international investment system is reformed to serve the interests of the states. As it is now, is just serving the interests of investors, but not of the states and the people, in particular of developing countries. I fully agree with a comment made by Claudia about the essential interest should be to protect the right of the states to regulate. Clearly, in particular in the area of health today, but also in the area of protection of environment, generally in protection of the society's interests. So, but the protection of the right to regulate for the public interest, I think, is one of the main issues that we need to address when revising or when some states are looking at new investment agreements like this. I certainly appreciated very much the different proposals made in relation to just terminating the agreements or reviewing them. It is very important to remind the governments that they have the power to do that. So these last comments about the awareness, I think is also very important, awareness at the high political level. The first place, they should know that, as it was mentioned, these agreements will not bring automatically more foreign direct investment. Secondly, these agreements may pose more problems than solutions that our countries are looking for. So I think all this needs to be taken into account while negotiating new agreement, if this is the case, but it's important to remind the governments that they can terminate. It was mentioned that there is a need of a very particular assessment case by case, but this should be done with the aim of freeing governments, of giving the governments the power to regulate in the public interest when necessary, not to be stopped by the interests of particular investors. So thank you very much again. It has been extremely useful discussion, and let's hope we remain in touch, in contact, in order to move forward in the interest of developing countries and the reform of this very peculiar international law system. Thank you very much.
Thank you, sir. Daniel, is there any last words you'd like to say?
Yeah, thank you.
And you could give also the thank you.
Thank you very much, Mariama. Well, first of all, thank you very much, panelists. It has been an amazing and really good debate. It has clearly shown up that there is a lot of interest and a lot of possibilities in this particular issue of ISDS and COVID-19. We also thank all the participants in the webinar. We know that this has taken time of your busy schedule, so thank you very much for sharing your time and particularly to share your interesting questions. Just to end up, I think that the South Center is open to work with all partners and also their developing countries and other stakeholders in looking at this particular issue, but also considering that there is a need for a coordinated response, was mentioned by the majority of panelists. A coordinated response not just to face the issue of COVID-19, but other future crises that might come. and a coordinated response to build resilience for the state in face of those crises and such future challenges. So I think that this was a good first step for the South Center to continue on this work, but we will strengthen our work with developing countries and other stakeholders. Thank you very much, Mariama.
Thank you very much, and thanks to everyone for your time, your effort, your energy, and all the work you have yet to do. And it seems like there's a lot more work to be done. So thanks everyone, Chantal, Lise, Rosalind, Professor Samoria, and Claudia. And thank Diana and all the 44, 45 or so participants who have been here. Thank you for your questions and your engagement, and look forward to seeing you out in the space. And thanks, Sanya, for posting the CSO declaration, and we'll keep putting it on. So thank you very much. And with apologies again, we're 19 minutes over time, but I hope it's been worth it. Thank you.
Thank you very much.
Bye-bye.
Goodbye. Thanks.